Okay. This, again, use of force models of practice in search of a science. In his classic treatise on U.S. policing in 1970, Egon Bittner argued that the use of force was the core competence of police work and a practice requiring systematic study. At the time, Bittner noted that the unlawful use of force by police was essentially unrestricted and by law, and that instruction officers received regarding it largely amounted to sermonizing and sanctimonious homilies to be humane and circumspect. Much has changed since Bittner. First, the role of policy as a means of controlling police behavior and the development of training on the use of force emerged in the early 70s in response to police violence used against civil rights and anti-war protesters in the preceding decade. This led to establishing federal agencies such as the Law Enforcement Assistance Administration and the creating state-level commissions across the U.S. to create police standards and training. Second, the creation of national standards to guide police practices through policy and the institutionalization of national and state-level accreditation processes for individual police agencies spurred the adoption of model policies and training practices advocated by different professional associations seeking to reform policing. Third, the legal landscape regarding the use of force was significantly altered by two Supreme Court decisions, that is Tennessee versus Garner and Graham versus Connor, circumscribing the conditions under which the police can exercise force. Specifically, Graham concluded the reasonableness of any use of force is not capable of precise definition of mechanical application. The court also noted that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight, and that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. These court decisions necessitated police agencies to adapt their use of force policy and training accordingly. Fourth, research on the use of force moved from analyzing the structural organization and individual correlates of use of force incidents to dissect the use of force event as the product of human decision-making. This focus emphasized the interplay of physiological and psychological factors that might contribute to that decision. One highly influential decision-making model, the OODA loop, was adapted from military pilot training in the 1950s and imported into policing. Further, the use of the force continuum was created to structure officer decision-making processes and the force options available to officers, with primary emphasis on when and how to escalate force options. These models evolved from simple to quite complex representations and incorporated into training and policy, but these have been criticized as rigid and mechanical and in need of replacement with models that emphasize critical thinking skills and de-escalation. However, all these models explicitly or implicitly assume that officer decision-making can be parsed in precise ways and explained by cognitive processes in the brain the officer is employing prospectively in that force decision moment. This reflects what Emily Martin terms neuroreductionism, the reduction of the person to the operation of the brain such that social and cultural contexts are eliminated or reimagined as outcomes of brain processes rather than as part of what creates subjectivity. Finally, force science, our focus today, emerged in the early 2000s and has influenced the research and training landscape on the force decision, albeit not without controversy. The lamination of science onto the force decision-making process produces post hoc rationalizations of the reasonableness of the force decision. For the balance of this paper, we will demonstrate force science claims in courtrooms to illustrate the ways science is invoked by force science experts. In 1999, Bill Lewinsky, a psychologist by training, published an article in the non-peer-reviewed journal, The Police Marksman, explaining how police officers could justifiably shoot someone in the back. Lewinsky's research into police performance in high-stress situations such as shootings led to the creation of the Force Science Institute in 2004, a private business which trains thousands of people per year in the science of police action and reaction. According to the FSI website, Force science is the research and application of unbiased scientific principles and processes to determine the true nature of human behavior in high stress and deadly force encounters. While the FSI has grown in size and stature, it has not been without controversy, reflecting what Jasanoff describes as mainstream science pushback to junk science. Force science has been branded a pseudoscience, with esteemed policing scholar Sam Walker describing FSI as providing questionable research support for a threat-focused vision of police work that eschews de-escalation and tactical disengagement in favor of a warrior mentality. Lisa Fournier, former editor of the American Journal of Psychology, writes that Lewinsky's claims that perception and judgment can be separated in time from biomechanical motions and parsed into discrete processes are not supported by the perception or attention literature. She notes Lewinsky's research employs subtraction logic, a discredited idea based on the faulty assumption that by subtracting out the time it takes to execute one action, you can figure out the time it takes to do others. Legal scholars Egley and Schwartz argue that the FSI, in conjunction with Lexipol, another private police training business, has been at the forefront of opposing use of force reforms. Ironically, months after the United States Justice Department criticized Lewinsky's research as lacking in both foundation and reliability, it hired him to testify on behalf of one of their agents and subsequently paid to send numerous employees to FSI training. Other indicators of pseudoscience include evasion of peer support and the absence of safeguards against confirmation bias. By our calculation, 40% of Lewinsky's early publications on the FSI website are in the Law Enforcement Executive Forum, a publication, not a peer-reviewed journal. Lewinsky's research focuses solely on the officer's side of the force encounter, leaving him open to confirmation bias, although he stands by the veracity of his research, claiming critics are jealous of FSI's success. Force science is not alone in being termed a pseudoscience. Pseudoscientists, sometimes referred to as 40-hour experts, come from fields such as footwear and tire impression, latent fingerprint comparison and analysis, and arson investigation, to name a few. Among its curricular offerings, the FSI offers such 40-hour certification trainings nearly every month, producing a large number of force science experts touting their expertise in use of force trials. Lewinsky himself no longer testifies as an expert witness. Rather, he refers attorneys to force science certified experts to testify in trials. Thus, Lewinsky's Institute has become a middleman and clearinghouse in the expertise market, reflective of what Jasanoff calls the commodification of the expert. One case our team researched that exemplifies the potential problems with force science is the 2017 case of Officer Roy Oliver, who shot and killed Jordan Edwards in Balch Springs, Texas. Oliver and his partner, Officer Tyler Gross, had been dispatched to disperse a large house party of local teenagers. While officers were speaking with the party host, they heard multiple gunshots outside of the home and ran to investigate. Gross began scanning the crowd of panicked teenagers while Oliver went to his patrol car to secure a rifle. Gross was attempting to stop a vehicle whose driver ignored Gross's command to stop as Oliver was approaching from down the street. Oliver believed that the vehicle was about to hit Gross and began shooting at the vehicle. He continued shooting as it drove past him, killing a teenage passenger, Jordan Edwards. Gross did not fire his weapon. Of note, no one in the vehicle or at the party was involved in the gunshots heard by the police officers. Oliver was put on trial for Edwards' murder, and 2 force science experts were hired to testify. Philip Hayden, the prosecution witness, testified that Gross was never in any danger and that Oliver's decision was unjustified. Jay Coons, the defense witness, testified that based on the principles of force science, the shooting was justified. To bring experts into court, a certification process establishes their credibility in the field of expertise and potentially their field's credibility vis-a-vis a normative layman's notion of science. In its finding of facts, U.S. courts do not use neutral experts, but rather allow competing sides to hire expertise. As Jasanoff notes, what the common law adjudicator sees in practice are 2 carefully constructed representations of reality, each resting on a foundation of expert knowledge, but each profoundly conditioned by the culture of expert witnessing as it intersects with the interests, ingenuity, and resources of the proffering party. In court, use of force experts are routinely asked about their scientific training and typically respond by invoking educational credentials. In court, force science is presented as including physics, biology, kinesiology, and psychology. In their testimony, these experts utilize a combination of peer-reviewed and non-peer-reviewed publications and their own experiences and beliefs about how police or suspects behave. As such, well-established facts like the physiological existence of reaction time are blended with and lend credibility to less credible theories of, and sometimes pure opinions about, decision-making, rationality, and social interactions. During the expert proffer hearings, both Coons and Hayden made over 25 wide-ranging points about their qualification. Both testified they were being paid and had testified in previous trials where they had been certified as expert witnesses. Questions covered their military, policing, and educational experience. Each had doctoral degrees. Hayden received an EDD, which he described as dealing with the human factor of education and psychologically, how do they learn, how do they perform, what their actions might be, and how they perceive themselves. These credentials were linked to use of force expertise through reference to his network of associations. When asked if he knew Bill Lewinsky and about force science, Hayden testified they had been friends for over 30 years and that he is a board member of the Force Science Institute. Hayden also discussed his military and professional career with the FBI, including his many instructor positions and publications in the FBI's in-house journal. Coons listed his experiences and rank as a captain in the Harris County Sheriff's Office, as well as emphasizing educational credentials. Coons had a doctorate in criminal justice and teaches courses in ethics, organization, administration, and statistics at local universities. 5 months prior to the trial, he was certified through the Force Science Institute. Asked by defense if he felt qualified as an expert to talk to the jury about use of force and the scientific part of it, the human factors, he replied, "Yes, sir, I do." In both cases, the focus on witness credibility emphasized their police career experiences rather than the validity of their scientific knowledge. Predictably, these experts differed significantly in their interpretation of Oliver's decision to shoot by defining the decision-making time frame in radically different ways. Coons focused on the moment Oliver aimed his weapon and argued, consistent with the Supreme Court, that he made a split-second decision. He used the OODA loop to demarcate decision zones. To do this, he used the prosecution video's timeline of events combined with force science reaction time research and assigned specific fraction of a second time frames within which he claimed Oliver was progressing through the phases of observe, orient, decide, and act. He then used these decision zones to claim that what we can actually What we can see is actually Officer Oliver, made the decision to stop shooting before he ever fired his first shot. At which point the defense used a rhetorical strategy to lay claim on scientific validity, asking, and that just doesn't seem possible, but all of the research confirms that, to which Coons respond, it's solid science, it's solid science. Hayden also discussed reaction time, but unlike Coons, does not explicitly reference the OODA loop in his testimony. He asserts the scientific validity of force science research, for example, describing Lewinsky's Tempe police study, stating it was very clinical situation. It was very, very clean. It was done in a laboratory type atmosphere. Using these findings, he concludes it takes about a quarter of a second for a person to decide not to shoot, although it could be faster or slower depending on the person. However, when asked whether Oliver was justified in shooting, he asserts that Oliver's decision-making time frame was 9 seconds, which is the period of time from when Oliver removed his rifle from the car to the first shot. Although these experts testify extensively on reaction time and action-reaction sequences, there is no standard or agreement for understanding how this applies to a decision to shoot. Hayden implies that a decision to shoot can begin as soon as an officer takes out a gun, while Coons narrows the time frame to a fraction of a second. In the end, the jury found Oliver guilty, and he was sentenced to 15 years in prison. The use of force in policing is problematic, leading to court cases where the boundaries of reasonable policing are increasingly contested. For Bittner, the use of force represented a failure, as he argued that all the skill and craftsmanship of policing should be geared towards not using force. What force science has done is to provide the veneer of scientific legitimacy justifying the use of force, no matter what the circumstances. Force science has developed into a court-oriented business, producing both questionable research and expert witnesses. In our estimation, following Jasanoff, this is a science created for courts. While some of the claims are drawn from actual sciences, the way these claims are applied to the use of force encounter is unsystematic, contradicts the scientifically accepted findings from the perception attention literature, and is biased toward the expert's advocacy position in court. Although Hayden and Coons both refer to themselves as use of force experts, this is not a field or a profession in the classical sense. Rather, they build their credentials on a network of activities and associations. In this way, they resemble the non-scientific forensic sciences described by Sachs, who stated that such experts neither borrow from established science nor systematically test their hypotheses. Their primary claims for validity rest on anecdotal experience and proclamations of success over time. Thank you.